This is the fun part. This is the dry part. I hated writing this section of my book, I'll be honest with you. This is the one that I thought was sort of the most complicated and less fun. And that's understanding appellate standards of review. And I think partly why it's not fun is as practitioners of family law, we're appealing something, our gut feeling is the judge got it wrong for some reason. They got it wrong because they applied the facts incorrectly. Again, the importance of the facts. They got it wrong because they went off the deep end in the law. But the bottom line is emotionally, they got it wrong. So I don't really care what my standard is to the appeals court. They got it wrong. Fix it. I need help. They went off the deep end here. They put they awarded 97% of the marital estate to one party and 3% to the other. Help me. So what are standards? Well, where the appeals court is asked to review the facts, let's start with that, or where the appeals court is asked to review the exercise of discretion by the lower court. So you first have to ask yourself, what am I really trying to do from a legal perspective? Am I saying to the appeals court that the facts don't make sense, that this shouldn't have been found? Most of the time, that's going to be tough because usually most of these trial judges are paying attention to most of what you're saying. And usually, you might not agree with their interpretation of the facts, but the facts tend to weigh against you. But you got to be careful because if you don't make that argument, all could be lost when you're standing in front of the appeals court. Or when the appeal court, when you're asking them to review the exercise of discretion by the lower court. In other words, the trial court got it wrong. By the way, this is in the new rules. I just reminded by this lower court. They are asking you to always refer, write that down. It's not the trial court, it's not the judge. It's the lower court in your briefs. We'll get to that in a few minutes. Okay? They codified that in the new Master's Rules of Appellate Procedure. Always refer to the trial judge, the trial court as the lower court. That's what it is, okay? So you got the price of admission, lower court, there you go. That was a bonus. So when you're asking appeals court to review discretion, you're asking them to saying to them that, look, the lower court just they're not supposed to do this. My favorite example is evidence, is that they relied on something outside of what was heard within the trial, that they're relying on something else. Hard to find, but it does happen. When you're a single judge system, they may have taken some form of approach to the case or have some form of inherent bias or whatnot, where they're starting to rely on facts that never came up at the trial. If you can find that, that's a good avenue of appeal. Yes?
When making a judgment, can they rely on facts that came up in other hearings, like at a temporary motion hearing? I
would say no. Absolutely, because the record, we're going to get to the record, but the record that the appeals court's going to rely on is the trial record, because that's the purpose of a trial. Is everything comes into the trial. So the pretrial memorandum, the temporary, they all go away. You have a right to your day in court, so no. And if they do it and they found it, then I think you argue that they're relying on facts that were not within the trial, and you didn't have an opportunity to rebut those facts. I think that's sort of the nature and the essence of due process, that everybody, even in the probate court where we settle almost all of our cases, you do have a right to be heard. Anything else on that? All right, so standards of review. De novo, that's my favorite one because I like saying the word de novo. That's when an appellate issue involves the interpretation of law. Basically, de novo means new. It's from the beginning. This is fun because it's usually you're talking about some kind of new law, new statute, and this gives the appeals court the greatest form of discretion because they're going to look at it as if nothing went before you. They're going to start again. That's de novo. Another one is legal insufficiency. I call that the no evidence one, when really it just makes no sense, that it is legally insufficient for father to have custody when he hasn't seen the child in 5 years because he's been in prison. You know, it doesn't make any sense. It's just the evidence it was not there. It's legally insufficient. There's no evidence to support what a judge has done. The big one, as I turn to the next page, is the one on the bottom. It is abuse of discretion in family law cards. The abuse of discretion is universally applied to most family law appeals. This is where most of your appeals will be evaluated upon. Property division, custody, alimony, child support, and the like. And here's where it gets a little tricky. The problem, as I said, what's the theme here? Do not file the appeal, okay? Don't do it, all right? That's the theme, and I mean it. And one of the reasons why appellate practice is so difficult, and why my book is the only book that's ever been written on appellate practice for family law attorneys. That's a quick plug. That was like time for the commercial. And by the way, I didn't say this at the beginning. I should have said at the outset. I will, because you're nice enough to sit here and come out in the rain, I will auction off for free. You have to give me a card. We'll do at the end my book tonight. We'll do a raffle, and the lucky customer will walk away with a free book tonight for coming, because I do appreciate you coming out tonight. So another commercial. But one of the reasons why it's so hard to do family law appeals is because we give judges the most discretion in any matter is in family law. And why? Why? Because they're the closest to the action. It's all about facts. They were there, to your point. They were there at the temporary orders when the husband or the wife lied. They were there at the pretrial. They got the issues. They have all this body of information before they even get to a trial. Then they get to assess the credibility. They get to assess the witnesses. And appeals courts, they hate family law. They hate it. What do you want me to do? I don't care who gets the car. I mean, they want to do fun stuff. You know, they want to decide constitutional principles and Massachusetts Declaration of Rights. They want the good stuff. They don't want to know. They don't want to decide if somebody's going to pay $12.50 a week or $8.75. You know, it bores them to tears. And so that fact, it bleeds through from the trial judge, the lower court, all the way up to the appeals court. That's why I say you're going to be very, very choosy, very cautious, very careful in filing and choosing to file an family law appeal. And it's because of that discretion. Because if most of the time you're arguing about discretion, you're already beat. Because the appellate court is going to be biased from the beginning to give that judge the most discretion they possibly can. Because when they sit in that room, and think about it, if you're going to be one of three people with all your law clerks and somebody's talking about abuse of discretion, they turn to each other, well, I don't know. And you know, I don't know. Well, the trial judge, they were there, they know the most, let's affirm it. I mean, that's the mentality that you're fighting against when you're doing an appeal in family law. And you have to keep that in mind because the odds are stacked against you. And that is first and foremost because of the broad discretion afforded appellate court trial judges in the probate court. Next. This is an always fun one. To me, it always comes down, if you're going to bring a matter, to what your gut feeling is. Is there something there that really gets your attention? Is there something there that makes you feel, you know, something's wrong, I'm going to take this case? Something requires that urgent plea. Again, an appeal is that urgent plea. It's that emergency. Something doesn't feel right. And I think you have to trust your instincts. Understanding that the odds are against you and your client, understanding that broad discretion will be afforded trial judges by the appeals court, understanding that it might be better avenues to appeal. But if you can go through all those tests, if you can go through all those facts, if you can go through the record and it's there, and something doesn't sit right that you really feel cries out for justice, then go with your gut. All right, now we get to practical matters. Before I get to practical matters, any questions? Anything at all? All right, good. We're like halfway through. I never get through. I've given this talk 3 times. I can never get through it. I try not to be verbose. I like the questions, so keep the questions coming. All right, so let's talk about the mechanics of an appeal. Every appeal starts with a notice. It's pretty easy. I appeal this judgment, blah, blah, blah. But, properly format it, timely file it. It's 30 days. When does the 30 days start? Let's get the microphone on Attorney Solaris for paying attention. This is making me feel better about my training over the last 10 years with Attorney Jennifer Solaris.
The date the judgment's docketed, not
Yes.
necessarily the date on it.
Yes. Look, the appeals, the probate court's messed up, okay? Everything's on paper. It's not electronic. The clerks are overworked. Judges are overworked. They have very little resources, So you get the judgment, on February, let's say I go back to February because it's my birthday month. February 1st, it's dated December 6th, and you look at it and your first instinct should be to panic. You start to cry. Where's my 30 days? I'm screwed. Don't. It's not the date on the judgment. It's not the date on the judgment. It's the date it's actually docketed. And what usually happens is the clerks understand this. They know the mail's slow. They tend to docket it when it goes out, generally. Don't rely on that. That's just sort of my summation of experience. But always the first thing I do when I receive a judgment is ignore the date on it, and I will call the clerk and find out what was the date it was docketed. Because that timing starts everything. That starts your post-trial motions, that starts your notice of appeal, and that's the operative date to keep in mind. So file it within 30 days. A contempt, I think that you should file it immediately in less than 14 days. I've seen it both ways. It's not entirely clear, but I think technically there are some more technical rules, so I caution you. I didn't look it up before I came here today, but I think contempt judgments, I think technically, if you read the statute, are less than 30 days. So that's sort of keep that in mind. But I always, again, there's no shame in filing multiple notices of appeals. So you can file it immediately, so it's in there, and then refile it after the disposition of what? A Rule 59 or 60, which makes what? The initial notice of appeal inoperative. So keep that in mind. That's the other thing I always try to teach people. All right. So what goes in the notice of appeal? I think that family law requires a little bit more. Technically, just appealing it will get you through. I appeal the judgment dated such and such date by such and such judge, J, the parentheticals. That'll get you through the door. But I strongly think that, again, family law is unique. It's novel. It's different than other areas of the practice of law. My best practice to you would be to put specifically what you're appealing. Because you're not generally appealing the judgment of divorce. You're glad these people are divorced. No one's saying, I want to stay married. What you're really appealing is the operation of certain aspects of the judgment. And so I think it's very important. The other thing is, again, appellate jurists do not like family law matters. We only have in Massachusetts one former family law jurist, Judge Blake. Couldn't make it tonight. I asked her to do it with me. Just sorry. I tried, but we'll do the next one with her. But it's very important to understand that they're going to have limited patience, limited time. So how do you operate in that realm where it's against you? Well, one way to do it is limit the issues. If you're not appealing child support, don't say I'm appealing the whole judgment and the whole kitchen sink. Say I'm just appealing alimony. That's it. I don't care about child support. I don't care about the division of assets. And you can do that in the notice of appeal. Now, maybe you do need to appeal the whole judgment because maybe something down the line, then I forgot about that. That does happen. But if there's really one critical issue, you're really only looking to have your day in court with the appeals court on one salient matter, then limit your appeal to exactly what that is. Question, go ahead.
So I'm never trial counsel in these matters. I only do appeals, and sometimes I've got to act relatively quickly. I haven't even seen the record yet for the appeal, so I may not know all the issues. What about doing something like we appeal the judgment, including without limitation, issue A, B, C, which in theory preserves rights to appeal other issues down the road, although I recognize failing to mention may be a problem, but it seems to me that's a reasonable compromise.
Absolutely. What I would do, just appeal the whole, this is the other way to do it, appeal the entirety of the judgment. That way you preserved your client's right to appeal. But then when you brief it, appeal what you really want to appeal, because by then you know. And that way you get best of both worlds. I mean, to me, sometimes you'll know going in, I'm really only trying to appeal one of four things. I'm just going to be consistent. But if you really don't know, if you feel like, you know what, the alimony might go with the child support, or maybe that's not an allocated issue, and I don't want to commit myself and potentially face, well, you waived it by not notifying us that you're appealing that issue, then by all means be broad, but then narrow it down when it comes to your brief writing and just focus on that. Steve. You got it. He's coming. They're recording it, so you get to be on.
Thank you. You may have touched on this, but I've encountered an occasion where party wanted to appeal, but wanted the divorce to be final at the same time. Do you have any views on that as well?
Well, here's the thing about that's a good point, and it's actually something I was about to say. Remember, we didn't touch upon this yet. Your notice of appeal in a domestic relation case does not stay the operation of your judgment. So your judgment is live unless you receive a stay. So you have to keep that in mind. That's another reason why a lot of people don't want to appeal family law matters. Because I'm going to tell you, a lot of times, unless it's a sum certain or something really interesting, and this includes child custody, the appellate court, the trial lower court is not always going to stay the operation of that judgment, which means the divorce is final, the alimony is live, has to be paid, subject to a contempt, even if someone disagrees with it. The child support has to be paid. The division of assets potentially have to be divided. We do not have automatic stays in domestic relations, which I've always had a little bit of a problem with it, but then if you think about it, because we're dealing with people's, again, most intimate treasures, possessions, lives, their lives have to go on. And that makes it even more difficult in many ways for people to appeal matters, because the judgment is live and valid. So it's always good practice. One of the things you should always talk to your clients about is, what do we do in the interim if we're going to file an appeal? Do we stay aspects of the judgment? Do we not stay it? And then what happens? If you stay it, the way it works in Massachusetts, to cover it for a sec, a lot of times the trial judge may reject your stay. You lose it, you got to bring it up to a single justice. And then you're dealing with single justice practice. And domestic relations and single justice practice, good luck. Good luck. I mean, it's very, very difficult, because at that stage, it's hard. I mean, it's like it's filing a needle, and a hay, and a bale of hay to get a single justice to do something in a lot of these cases. I mean, I've had child custody cases, international cases, where a judge wouldn't stay the operation of a judgment with a child leaving the country. So, including federal and state. So you got to really have that conversation that, if we appeal, doesn't mean that the game, that you have to follow the rule of that judgment. So one of the things about the significance of a notice of appeal, and something to keep in mind, I'll cover this quickly, is that what's really happening legally is you're transferring jurisdiction of that case from one court to the other. That's what the notice is, and that doesn't start with the notice. It begins after the record has been assembled by the lower court. So it's your duty, if you're, as the appellant, to get the transcripts, to notify the court of the assembly of a record, and when that happens, you'll get a notice from the lower court stating that they're sending it over to the appeals court, and then you have 2 weeks to pay your fee and docket it. And when that, in the appeals court, and when that happens, you've now taken that matter from the lower court to the appeals court. And what's really happening jurisdictionally, you've changed who's handling the case. And what that means, and that you should keep in mind, is that if you have ancillary matters or matters that directly touch upon your appeal, the matter is not within the lower court. So if 6 months later you want to file a modification action, you may be able to do so, but you need to get permission of the court that now has the matter, which is the appeals court, to go forward on your modification. So understand that there's a jurisdictional change temporarily. That's why we have the word remand. What remand is doing at the end of an appeal is they're remanding the jurisdiction of the matter back to the trial court. So you need to keep that in mind, because particularly in family law, you may have matters that you want to have heard, or maybe you want to do a modification and appeal. You need to seek out, in this best practice, to receive permission. Now, a lot of times people don't do it. Sometimes you're in the opposite end, and someone files a modification. That's when you stand up and you tell the court you can't take this case until you get permission of the higher court allowing this to go forward. So it's an issue to spot and to dive into when it happens. Anybody question on that? All right. The technical requirements, where do you file notice of appeal? You file it within the lower court. A lot of times people file it in the wrong place. Maybe you got there's no pro se people here today, so I won't pick on them, but they may file it in the wrong place, and they'll still accept it. They'll send it back down, but it goes in the lower court, in the trial court. The contents are fairly simple. I told you I'd raffle off my book, or you can buy it, so you can read about it there. For the interest of time, we talked about that. 30 days, time standards, service. Service is interesting. I think it's good practice, although maybe not be technically required to serve it on your counterpart. I have not dived too much into the new rules, but so I don't know if they changed that one. I didn't see it in the major changes, but I think it's good practice if you're going to file something with a court, to serve the other side with a copy of it. But in the olden days, and may continue to this day, actually, the clerk of the court is supposed to notify the other party, the lower court, that you're filing an appeal. So some traps to avoid. We covered this a little bit, but just a quick reminder that, again, if you file a Rule 59, a 60, a 52B, and Massachusetts pretty much tracks the federal rules, a motion for relief under 50B, that again makes your appeal first notice inoperative, and you have to file a new notice after the motion under 59, 60, or the like has been docketed. I always say that many times because I really do feel that that's the biggest mistake that a practitioner can make, and it's hard for family law attorneys to wrap their, I filed my notice, because a lot of family law attorneys don't regularly do these. Always check your local rules. We'll come to that point now. It's right here. They've changed a little bit. They track more the federal rules now. They were amended on March 1st, 2019. They went into effect. So they were amended last year, and now we're functioning under these rules. A couple spots to throw out there to you for you to keep track of and to pay attention to. We're now measuring by word count. Again, appeals are technical. Certain forms of font need to be used. Certain technical aspects in terms of how you lay out an appeal have to be used. And word count does matter. So you do need to check on your word count. You have to certify it now to the court. There's a certification now that has to be filed, right? At the time of appeal, that wasn't there before, certifying that you've complied with all the technical requirements of an appeal. There's 11,000 words now for a principal brief, 4,500 for a reply brief. Reply briefs are always short. So pay attention to these rules. They're easily to get. And there's some very good material on the appellate court website that kind of goes over the rules a little bit and gives you some really good concrete examples. So I would, given that the rules have changed, if you haven't filed an appeal in the last year, I strongly, and this happened to my own office, I strongly encourage you to avoid rejection the first time and get it right, and make sure that you follow the technical rules and use what's on the website. There's a really good how-to guide on the website in Massachusetts. All right, so now we come through my favorite part, which is understanding the difference between the record and the record appendix. The record is everything. Just think of it as everything. Is that what the appeals court clerk reads? Absolutely not. Not in a million years. The appeals court clerks only read and pay attention to the record appendix. The appeals court judge only reads and pays attention to the record appendix. The appeals court judges in Massachusetts, do you know how they receive their documents and everything nowadays? iPads. Each appellate court justice has an iPad. They don't get paper. They get an iPad. So everything they see is electronic, and the record appendix is what they're going to review, and that is also going to be reviewed electronically. So your record appendix is really your key principles and components of what you want a reviewing court to review to determine the validity of your appeal. It's the important stuff, not the fluff, not this, that, or anything. It's what you want them to see. And it's the only thing in your brief that you refer to, and that you have to show the court where and on which page of the record appendix you're referring to make your arguments. So, quickly on duty, when you're the appellant, it's your responsible to ensure that the trial record gets up there. And back to record appendix, there's a rule in Massachusetts regarding the creation of it. There's language about maybe doing a joint one. In practice, I've never seen it. I wouldn't do it. I'll give you big advice. In most situations, I wouldn't do it. I'm not making absolute, but I think generally, if you're the appellee, let them, I shouldn't tell you all this, but let them put what they're going to argue to, and then see if it's legally sufficient to make their arguments. And if it's not, you're good, right? If you're the appellee and you read it and they left out the three 1099s that showed the husband was paid $3 million last year, not $600,000, and that was very clever of them, then what do? You submit with permission of the court your own record appendix as a supplement. So that's a little gamesmanship, but I think it makes sense, particularly in the family law realm. Trial transcripts will be the obligation of the appellant, who's the moving party. I won't go into it in terms of time, but that's Rule 8, discusses it. We did talk about something else briefly. We talked about that producing the transcripts is the duty of the appellant, but also what do you do when there are no transcripts? The rule is if there's no report of evidentiary proceedings at a hearing or trial is made and the transcript is unavailable, you need to file a motion to reconstruct the record within 14 days of filing the notice of appeal. The parties will confer and construct the record. Well, good luck. I think that's very, very difficult in most of these cases. You can agree on a statement of the record. The parties intend to submit an agreed statement as the record on appeal in lieu of the procedure set forth, blah, blah, blah. You can do it within 14 days or 28 days. The parties shall submit to the lower court an agreed statement of the record. I think that's, in practice, is very difficult. So I think it really depends on the case and what kind of case you can make with the record that you have, or what you can present as your own record. But that's where the rule is. Real briefly, the use of confidential information. You got to be careful with that, particularly in the family law context. Financial statements, guardian ad litem reports, and the like should generally, if you're going to be relying them on the record appendix, need to be segregated out, and you file your own confidential supplement and keep those items that are subject to confidentiality in a separate record appendix. Talked about the importance, we talked about the supplement. So now we turn to the writing of the brief. So I'll be brief on the writing of the brief. Your objective in writing a brief is to make the job easier for the appeals court. I do not think you're going to get a letter grade on this. You're not. Your job is not to write the most legalese, formalistic, beautiful piece of prose that's ever been read by a would-be clerk or a appellate judge. Your job is to keep it simple, stupid. Literally. Put it out there in simple, short, declarative statements. What happened, what the error is, what the law should be, and what relief you're seeking and why. Do not state 27 cases. It's not how much volume is there. It's not how many semicolons are there. It's not how many things you put in parentheticals. Don't do that. Make your case, make it clear, make it obvious, and get out. Because what you always want to do, no matter who you're in front of, the trial court, an appeals court, the SJC, the Supreme Court of the United States, you want them to know, at the end of the day, when you leave, this is what that person wants, and I understand why. And if you've done that, you've done your job. And that's what you do in your written submissions, you do it in your brief, and you do it with an oral argument. So I'll skip ahead. What about oral argument? I'm going to tell you about oral argument. Oral argument is important. You learn in law school, oh, they've already decided the case. Bullshit. Not true. It's not true. Oral argument can make a difference. It can make a critical difference. And I would argue, it's in my book, but there's evidence of this. Justice Scalia said that at the beginning of his term, he felt oral argument was a complete waste of time. At the end of his career, he felt it was critical, important, and did make differences in cases. So it does make differences, and I would argue that the unique thing about family law is because so many times the same person that tried the cases before the appellate panel, that you're the one who knows the facts as well as anybody in the room. And your job is to show them how that judge got it wrong. And so the knowledge that you bring to the table and to the appeals court is second to none. And so you should use and welcome oral argument to make your case. I'll give you an example. In the Miller case, true story, removal. Giannis is out. I've written about it. You probably read what I wrote. It's gone. Okay? It's gone. Read Justice Gantz in the Miller case. Okay? Giannis is gone. It's best interest of the child. Period. I haven't brought it up yet. I'm out there fishing for that case. I've had two that just didn't work out. If you have that case, come to me. I'll take it. But it's gone. Read Miller. Why is it gone? Well, 2 weeks before we had oral argument in the Miller case, the New Jersey Supreme Court threw out the case that was predicated on Giannis. I got a little alert on my phone, Google. I said, this is interesting. The reasoning of Giannis has been rejected. Interesting. What else? Oh, just about every other state, or the majority of the states, have thrown out real advantage and gone to a pure best interest of the child standard for removal cases of a child out of a jurisdiction. Well, that's interesting. Dan, I didn't brief it. Oh, no. It's true, we didn't brief it. It wasn't really the issue, the SGC. I think it actually was the issue, and then the justice that took it retired, to be honest. I don't know. I've never asked anybody that, but that was always my inkling. And so we go before the court, oral argument. I argued that you should be best interest. I started arguing it. Justice Gantz and a couple of the other judges went with it, started asking me questions about it. I brought these things up when New Jersey just threw it out. Giannis was decided 35 years ago. And Justice Gantz started to smile and started asking me questions about best interest and the differences and what should be the law. Get the opinion months later. Justice Gantz, in a concurring opinion, adopts the reasoning that we argued in Miller as to why it should be a pure best interest of the child standard. The majority opinion didn't say they disagreed. They basically said they agreed, but it wasn't briefed. It wasn't briefed because it wasn't the issue. I didn't need it, but it was argued. And now I know what the standard is. It ain't Giannis. So keep it in mind. Oral argument can and will make a difference in your case. Questions? I'll leave it to questions for the last 5 minutes. We got 5 minutes? Anybody have any questions? Right there.
It's a more technical question that just happened to happen.
Sure.
You were talking earlier about it's 30 days. The notice has to be within 30 days from the date that it's docketed. I had the rationale docketed on, let's say, January 1st, and the judgment wasn't until 5, 6 days, 7 days later. Do you go by the rationale? Which we know if there's a rationale, there's a judgment.
Go by it's a judgment.
By the judgment.
It's by the judgment.
Okay.
The 11,000 word count for the brief,
Yes.
does that include your citations? Or can you put those in a footnote so that they don't count towards your word count?
Before I even look at the rule, I would say that includes everything. Because you don't want to play games with it. Lawyers have been sanctioned, and they may reject your appeal. And so if they reject it, and honestly, if you're right at the limit, you're offering a little too much. I think less is generally, as a general rule, is more. So I would do the word count on the software program, and as long as you're 11,000 or less, you're good.
So if the date of docketing governs the running of the appeal clock and the court does not enter it on the docket, is it a nullity? And should you then file a motion to enter the order?
Yes, you won't even have to file a motion. If you ever need something docketed, and I've had this experience a few times, you call the clerk of the court and say, I need this docketed. If that doesn't work, you can call, you may want to talk to the judge's judicial case manager or the judicial assistant or even the probate court, the registrar. But if you shake it around a little bit, they'll docket it for you. And most judges, I've had judges say, okay, I'll docket that right now. I've had that same situation with a judge, and it was docketed that afternoon.
What you include in the record appendix, can you talk about the inclusion of pleadings? Because they're not evidence, and I've gotten into some situations where counsel argue about the inclusion of pleadings in the record appendix.
I think it's definitely part of the general record. If it's part of the general record, you can include it in your record appendix. So you should include it. I mean, if you feel that it's going to mean something, it can be included. The other thing that I always do, and I suggest you to do this too, almost all the time, is when you're in front of a court in a trial, you should say to the judge, I'd ask you to take judicial notice of the entirety of the record that's been produced up to this point. And I've never heard a judge deny that, which means the entirety of the record is now within the trial record too. But there's you can put what you want in. So if it makes your argument, you put it in. And sometimes it has to be in because if it's a jurisdictional issue or there's a date that's operative that's important for the reviewing court to take a look at, it needs to be in there. And pleadings are part of everything is part of the record itself. The record appendix is really like your strategic choice of the building blocks of what you're going to argue upon to the appeals court.